Hi there, everybody. Thank you for joining us for our 6th installment of Sui Juris, Presenting Yourself in Court. Today we'll be focusing on the settlement phase of presenting yourself in court. Settlement has to do with kind of like the last-ditch attempts to avoid going to trial. By this point, the idea is that through the use of discovery tools, which are described in earlier videos, have brought you to a place to not only assess the material facts that can be entered into the court record and the evidence that can be brought to trial, but to really assess, again, the discovery, the strength of the lawsuit, especially for the other side, to see if it really makes sense going forward. Courts these days will oftentimes make it mandatory to have in many cases, a number of pretrial conferences seeking to settle the matter before it does go to a trial that would involve a jury. So today we will be focusing on discussing court-ordered mediation, court-ordered arbitration, offers of judgment, pretrial settlement conferences, and post-settlement documents. So let's bring up our screenshot. Got a really good one for us to share with you today. Let's see. There we go. Sovereign. The word sovereign is derived from the Latin adverb super or above, and the Latin noun regnum, meaning rulership or control, to be above rulership or control. Thus, sovereign means one who is above the rulership or control of another. Sovereign means not a subject or a slave. Okay. So, jumping right into our subject today. So salmon swimming upstream to spawn in an obstacle-filled river have a far better chance of accomplishing their goal than a case has of making it all the way to trial. Informal estimates are that around 90% of cases filed in court wind up being settled rather than resolved by the verdict of a judge or jury. This conventional wisdom is reinforced by a recent study led by Jonathan Hyman for the New Jersey Administrative Office of the Courts. Not only did just 10% of all of the cases in the New Jersey sample go to trial, but 12% of these cases settled after a trial had started. Thus, the Hyman study also confirmed another basic truth about litigation. It's never too late to settle. Settlement is a popular option for a number of reasons. As a plaintiff, that is the person bringing the complaint, think of the word complaint and plaintiff, against the person, the accused, who must defend themselves, and thus they are the defendant. As a plaintiff, you can take advantage of the time value of money. The dollar you get by settling now could be more valuable than the $2 you may get years down the road. Secondly, if you are self-represented, no matter whether you are plaintiff or defendant, the biggest benefit of settlement can be extricating yourself from a complex and often alien and hostile legal system. Also, you can save yourself the hundreds of hours you may otherwise have to spend doing legal research, talking to witnesses, gathering documents, engaging in numerous other case-related activities, and ultimately going to court. Thirdly, settlement affords both plaintiffs and defendants the certainty of a known result. By comparison, the outcome of a trial is always in doubt. Lawyers are fond of referring to trial as a crapshoot. Even the most solid case can occasionally succumb to such factors as lost exhibits, disappearing or forgetful witnesses, a hostile judge, or a rogue jury. Fourth, Settling often allows both sides to tailor the outcome to meet their specific needs. For example, if a business dispute goes to trial, a judge may be limited to awarding the plaintiff money damages that the defendant cannot pay. By settling, the parties might structure future dealings in such a way that the plaintiff is paid off over time or is guaranteed future contracts that more than make up for the money the plaintiff lost. For example, Daniel and Julia see an orange on the sidewalk. When both lunge for it, a nasty argument ensues. In court, a judge would probably have to award the entire orange to Daniel or Julia according to a legal rule, perhaps to the one who saw it first. However, in settlement discussions, the parties might realize that Daniel wants the orange to use its peel in a recipe, while Julia wants it only for the pulp to make orange juice. In short, the orange can be divided so that both parties can get what they want. In this way, a settlement can produce a mutually satisfactory win-win outcome that the legal system could not. For these and many other reasons, settlement is often in your best interests, even though it almost always means that you have to back off from an earlier hard-aligned position. Or, as Sir Winston Churchill put it, better to jaw, jaw, jaw than wage war, war, war. Because every case that settles is one fewer that the formal legal system has to find time and room for, legislators and judges think that settlement is also in the best interests of the legal system. After a complaint and answer are filed and before a case goes to trial, you will inevitably encounter judges, backed by court rules and procedures, encouraging you to consider settlement. Accordingly, this chapter provides a guide to the settlement procedures you are likely to encounter after the lawsuit begins and offers suggestions for dealing with them effectively. One way to achieve a fair and effective settlement before going to or being dragged into court is to employ techniques known collectively as Alternative Dispute Resolution, or ADR. Prominent among these techniques are negotiation, which is trying to resolve a dispute by talking to another person face to face, and mediation, which is trying to resolve a dispute with the help of a neutral third-party mediator. While you have undoubtedly engaged in negotiations and even informal mediations your entire life, these activities are more likely to result in fair and satisfactory outcomes if you learn and use the best information on these techniques. There are many good resources you can consult to increase your knowledge and skill in negotiation and mediation. Try settling before litigating. Waiting to try to resolve a dispute until after court papers have been filed ordinarily makes little sense. People should, and most probably do, attempt to settle their arguments before going to court. In fact, filing and serving a complaint is often proof that these early settlement efforts have failed. Paradoxically, a complaint itself can often serve as a settlement device in the sense that it represents one side telling the other, hey, I mean business, and you'd better be willing to compromise if you want to avoid a long and nasty fight. There's no real downside to trying to settle either. Your adversary isn't allowed to present evidence at trial about any compromise offers you make during settlement negotiations. Some resources. A book called Settle It Out of Court: How to Resolve Business and Personal Disputes Using Mediation, Arbitration, and Negotiation by Thomas Crowley. This contains information on the wise and effective selection of arbitrators and mediators, as well as how to craft workable settlement strategies. Another book, Getting to Yes: Negotiating Agreement Without Giving In, by Roger Fisher. This is considered to be the ultimate source on how to promote settlement by focusing on underlying needs and objective positions rather than personalities. Mediate, Don't Litigate, Strategies for Successful Mediation by Peter Lovenheim and Lisa Gorin. This is an excellent guide to the mediation process, including how to prepare for mediation and what happens during mediation. The Pocket Lawyer, Solve Your Own Legal Disputes by Marilyn Sullivan. This is written for non-lawyers and reviews the major alternative dispute resolution techniques. In addition, there are numerous websites where you can learn more about ADR, including adr.org or jamsadr.com and mediate.com. So, court-ordered mediation. Mediation is a descendant of dispute resolution methods used by village or tribal elders in ancient times. In mediation, you discuss a dispute with your opponent and a neutral, usually professionally trained, third person called a mediator. The mediator's role is to facilitate discussion, help the parties focus on concrete issues, and create and evaluate settlement proposals. And if the process gets that far, help the parties craft a written settlement agreement. A mediator has no power to impose a solution. Because mediations so often produce settlements, courts in many localities require parties in some kinds of cases to go through mediation before their cases can proceed towards trial. This is often called judicial mediation. Every state sponsors low-cost, voluntary, community-based mediation programs in specific fields, usually including neighbor disputes, consumer problems, landlord-tenant problems, and child custody and visitation disputes. In addition, many mediators who specialize in divorce and business disputes practice privately. The upshot is that mediation is so widely available that one way or the other, you may well have voluntarily participated in a mediation before going or being taken to court. Whether or not this is true, if you find yourself in small claims court, in a child custody dispute, or in a case involving what the courts consider a small amount of money, often $50,000 or less, a judge is likely to suggest strongly or even order you and your opponent to try mediation. Of course, if mediation does not produce a settlement, your case continues on through the court system. The American Arbitration Association at adr.org, to which many mediators belong, states that in most cases, mediation results in a settlement. Other mediation groups generally concur. Because it is quite likely that you will resolve your dispute with a mediated settlement and not a court judgment, you'll obviously want to guard against a disadvantageous result by preparing carefully for mediation. The following tips should help you achieve a satisfactory mediated settlement. 1. Understand the process. You will be attempting to resolve the case with your opponent personally, even if your opponent is represented by a lawyer. Lawyers sometimes attend mediations, but only to counsel clients and facilitate the discussion. However, recognize that a representative of a business or other large organization is likely to have prior mediation experience, will be savvy about and at ease with the process, and may be a lawyer to boot. To gain something of an equal footing, you should learn exactly how mediation works by reading a book such as Mediate, Don't Litigate, Strategies for Successful Mediation. Think in advance about what outcomes you would find acceptable. This is number 2. Think in advance of what outcomes you would find acceptable. Though a mediator may suggest ideas you haven't considered, getting a head start on your thinking can help you evaluate new proposals. While you want to keep an open mind, it is particularly important that you think in advance about an acceptable bottom line compromise position so that you don't find yourself conceding too much. 3, Bring documents and other exhibits supporting your legal claim. Even though no judge or jury is present to declare a winner or loser, tangible objects lend force to your points and provide you with psychological support. Remember the goal. Fourth and finally, remember the goal. The idea behind mediation is not to produce winners and losers, but to find solutions, often creative ones beyond the power of a judge to order, that meet both parties' real needs, but not always their fondest wants or expectations. Those specifics vary somewhat from state to state. There are similarities in how you are likely to encounter mediation as part of the formal legal system. A judge often has the power to order mediation of any civil lawsuit involving less than $50,000 and all child custody and visitation disputes. The parties usually have a chance to agree on a mediator of their choosing, but in some instances, the judge simply appoints one from a panel of available mediators. When a judge orders the parties to mediate, the mediator's fees are paid by the court. And mediations are more informal than trials. They take place in office settings, not in courtrooms, and operate without regard to evidence rules. Disputants are therefore free to say whatever they want and to back it up with whatever information they consider important. Here's a tip. Mediation of a single issue. Now, a judge can stop a hearing and send the parties to mediate a single issue and then return to the courtroom. Some courthouses have mediators on site who are available on an on-call basis to handle such matters. You will not get to choose the mediator, and the mediation will not cover the whole case, just the single issue that is hanging things up. You will not have to pay for the mediator. Typically, the mediator is either paid by the court or is a volunteer. Example, Hillary has invested $20,000 to become a partner in a bagel flour shop business started by Sky. Hillary asks for her money back after becoming convinced that Sky seriously understated the level of local competition. When Sky refuses, Hillary sues Sky for fraud and breach of contract. Sky denies Hillary's allegations. At an early stage of the litigation, a judge orders the parties to try mediation. During mediation, Hillary refers to reliable rumors I've heard about a national bagel chain's plan to open a couple of nearby outlets in the next few months. In a trial, a judge would probably rule that Hillary's reference to rumors, no matter how reliable, is inadmissible on the grounds of vagueness and hearsay. However, Hillary is entirely free to talk about rumors in mediation, and her statements have as much force as Sky and the mediator are willing to give them. If mediation does not produce settlement, and remember that neither a mediator nor a judge can force you to accept a mediated solution, your case proceeds to trial. For example, your opponent can't testify that during the mediation you admitted that I might have been driving a few miles over the speed limit. To help you understand how mediation works, consider how the mediation in Hillary's and Sky's dispute might unfold. In the book, Mediate, Don't Litigate, Strategies for Successful Mediation, it describes 6 stages of a typical mediation. The discussion below tracks those stages. So depending on the complexity of a dispute and the attitudes of the parties, the stages described below may be completed in an hour or 2, or they may continue over several days. But no matter how long it lasts, the mediation is likely to proceed as follows. Stage 1. The mediator reviews the goals and rules of mediation with the parties and encourages the parties to work cooperatively towards a settlement. For instance, a mediator might tell Hillary and Sky, hey, I encourage each of you to be honest with the other and to make your best effort at reaching an agreement. I won't take sides, and I'll keep everything you say confidential. Stage 2. Each side has an uninterrupted chance to describe that party's view of what the argument is all about and to offer possible solutions. For example, Hillary and Skye, in turn, could describe their understanding of the events, documents, and conversations leading up to the agreement. They could then each discuss their perceptions of the level of competition the new business will face. Finally, both could say how they want to resolve the dispute. Initially, for instance, Hillary might demand, "My money back right now," while Skye might say, "I want to keep Hillary's money in the business for at least 1 year, but I'm willing to sign a note promising to pay her back in a year with interest." Stage 3. The mediator tries to get the parties to identify and agree on the issues that must be dealt with to resolve the dispute. In this case, the mediator might identify level of expected competition and duration of the partnership agreement as issues that Hillary and Skye absolutely must discuss. Stage 4. The mediator meets privately, this is called caucusing, with each side to discuss the strengths and weaknesses of each person's position and to try to refine settlement ideas. In a private caucus with Hillary, for example, the mediator might want to discuss her ability to prove Skye's alleged misrepresentations and what information she might consider relevant to a decision to keep the partnership going. Stage 5. The mediator and the parties again meet all together to continue working towards a solution. Sometimes the parties might find it best to agree to adjourn the mediation for a week or two so that they can seek out additional information. When the mediation continues, all three will meet to see if settlement is a realistic possibility. And finally, stage 6. Mediation ends with a resolution that is summarized in writing or with a joint decision to return to the court system because agreement cannot be reached and further efforts to mediate would be futile. In this case, one possible settlement would consist of Skye agreeing to increase Hillary's interest in the partnership by 5 or 10% to compensate her for the unanticipated risk presented by additional competition. Another possibility would be for the two parties to agree to change their merchandise mix to avoid head-to-head competition. If an agreement is reached, the mediator would help the parties put it in writing, report back to the court, and file papers dismissing the case. The stages described unfold when a mediator is thorough and the parties are relatively cooperative. In a court-ordered mediation, when time may be short and one or both parties may not want to mediate, the process may be quite different, but an agreement may well result anyway. Statements made during mediation are confidential. Generally, settlement offers and statements made during mediation are considered privileged, meaning that they are not admissible as evidence at trial. This is to promote frank discussion during settlement talks to encourage settlement. For example, assume that during mediation you say, "Look, I'm willing to settle this if you pay me $5,000. I was a little bit at fault too." However, your adversary refuses to settle and the case goes to trial where you ask for $13,000 in damages. Your adversary cannot testify either to your offer to settle for $5,000 or your statement that you were partly at fault. Mediation agreements and mediators' own ethical rules also generally provide that mediators cannot be called as witnesses at trial, and mediators' statements and recommended outcomes are likewise inadmissible. However, you still need to watch what you say during mediation because your adversary might take advantage of your statements in other ways. For example, your adversary might embarrass you by repeating what you said to friends or business associates. Or your adversary might use what you say as a lead to locate evidence that can be used against you at trial. For example, assume that during mediation you say, "Hey, lucky for me, you never found out about Ed Jones. His information is really damaging to me." If the mediation effort fails and the case goes to trial, confidentiality rules won't prevent your adversary from calling Ed Jones as a witness. To avoid this problem, you and your adversary might sign a confidentiality agreement before entering into mediation. The agreement can provide that neither of you will disclose anything said by anyone during mediation to any other person, whether in court or out of court. The agreement can also provide that neither of you will offer evidence against the other at trial if the source of the evidence is information that was disclosed during mediation. In other words, evidence can be admissible at trial, subject to other evidence rules, of course, only if the offering party learned about the information other than during mediation. A confidentiality agreement with provisions such as these gives you added protection against disclosure or use of what you revealed during mediation. If your adversary violates the agreement, you would be able to sue for breach of contract if the violation causes you economic harm. Court-ordered arbitration. Many states give judges a second way to resolve cases involving less than $50,000 or so without going to trial. Court-ordered judicial arbitration, a kind of informal trial. In states that authorize both court-ordered mediation and court-ordered arbitration, you'll need to check your local court rules to find out whether you can have any input into which procedure a judge orders you to follow. If you and your opponent agree, it might even be possible for a judge to order that both procedures occur. That is, if court-ordered mediation fails to produce an agreement, you might ask the judge to order the case to arbitration. Like mediation, arbitration is designed to be a less expensive alternative to resolving a dispute in court. However, arbitration is more like a trial than mediation is. That's because in an arbitration, you and your adversary present oral testimony, documents, and other tangible exhibits to a neutral third party, an arbitrator, who is empowered to make a decision, usually called an award. Arbitrators are professionally trained in arbitration procedures and are usually lawyers or retired judges. Most courts maintain panels of arbitrators. A judge will appoint one for your case. The arbitrator's fee, often around $100 per case or hearing day, is paid by the court. In some localities, parties whose cases involve too much money to be covered by court-ordered arbitration can request voluntary arbitration, in which case they pay the arbitrator's fees themselves. Arbitrations typically take place in the arbitrator's conference room, and the arbitrator need not strictly abide by rules of evidence. Moreover, an arbitrator can try to fashion an outcome that is fair, even if the outcome is different from what might happen in court. After both parties have presented their evidence, the arbitrator will issue a written award deciding the case. The arbitrator can make an award regardless of whether the parties agree with it, unlike in mediation. However, an award resulting from court-ordered arbitration is ordinarily non-binding. That is, if you are not happy with the outcome of a court-ordered arbitration, you can reject an arbitrator's award and insist that your case be returned to the court system. When your case goes back to the court system, you are eligible for a trial, which lawyers often call a trial de novo, just as if the arbitration never took place. However, in many states, you can be saddled with court costs if you reject an arbitration award and don't achieve a better outcome at trial than you did in the arbitration. If neither you nor your opponent asks for a trial de novo, again, a trial de novo, which means a trial that as if the arbitration never took place. If neither you nor your opponent asks for this kind of a trial, the arbitrator's award becomes the court's judgment and is generally enforceable to the same extent as a court judgment. Example, assume that a judge orders Hillary and Sky's bagel/flower shop dispute to arbitration. After hearing evidence, the arbitrator decides that Hillary is entitled to dissolve the partnership and that Sky must return the $20,000 that Hillary invested in the business. However, Sky rejects the award and goes to trial in an effort to uphold the partnership agreement and keep Hillary's money in the business. Unless a judge or jury holds that the partnership agreement is valid, Sky will probably have to reimburse the county for the arbitrator's fee and pay Hillary's trial costs, though probably not her attorney's fees. Caution: mandatory arbitration. The court-ordered arbitration system we describe here is just one type of arbitration. Another form is non-judicial binding arbitration, in which the arbitrator has the power to issue an award with which he must comply. Without realizing it, you may have entered into a contract that provides for binding arbitration in the event of a dispute, and just about eliminates your ability to go to court. For example, if you have an account with a stock brokerage, are you a member of a healthcare plan, or live in a condominium, you have probably signed a document that provides that any dispute will be resolved exclusively through arbitration rather than through the court system. Courts generally uphold provisions for binding and exclusive arbitration, and they do not overturn arbitrators' awards so long as the procedures were followed fairly. Because arbitration procedures closely resemble trials, and arbitrators are almost always lawyers or retired judges, you should prepare for an arbitration in much the same way that you would for trial. For instance, you should figure out what you have to prove. See videos 8 and 9. Gather the documents you'll need and present any witnesses who can back up your contentions after working with them carefully to be sure that their testimony covers the key points. Nevertheless, you should find it easier to represent yourself in an arbitration because evidence rules are relaxed and the proceedings are likely to be less formal than a trial. Offers of judgment. An offer of judgment, sometimes called a statutory offer, is a written offer a defendant makes to a plaintiff proposing to settle a case on specified terms. See Federal Rules of Civil Procedure number 68. Most states have similar provisions. If you receive an offer of settlement this way, and it's even marginally reasonable, consider it seriously before saying no. If you refuse the offer of judgment, and you wind up losing at trial or winning less than the defendant offered you to settle the case, the judge may order you to pay any court costs the defendant incurs after you turn down the offer, such as witness fees and court reporter fees. However, you won't generally have to pay the defendant's attorney fees. An offer of judgment can unfairly pressure you into a quick decision if you receive it early in the case, before you've had a chance to evaluate the strength of your and your adversary's cases. If you receive an offer of judgment before you've had a chance to engage in informal investigation or formal discovery, see video 5, consider these responses. 1, ask your adversary to extend your time to reply. An offer may give you as few as 10 days to reply, and a request for a month or even longer is reasonable if the offer is made before you've had a chance to investigate. If the adversary refuses to extend your time to respond and later asks the judge to order you to pay costs under Federal Rules of Civil Procedure 68 or something similar, explain to the judge that such an offer would be unfair because the offer was made at a time when you could not reasonably have been prepared to accept it. Your argument will be stronger if you can show the judge that you asked for an extension of time to respond to a statutory offer and your adversary refused the request. So a sample offer of judgment might say something like this. Offer of judgment to Plaintiff Nellie in pro per. Defendant Really Big Corporation offers to allow judgment to be entered against it and in favor of plaintiff Nellie in the sum of $10,000 plus costs of suit incurred by plaintiff to the date of this offer. This settlement offer is made pursuant to Rule 68 of the Federal Rules of Civil Procedure and Rule 408 of the Federal Rules of Evidence, and is not to be taken as an admission of any liability or wrongdoing on the part of defendant Really Big Corporation. This offer shall remain open for 10 days after service of the offer on plaintiff Nellie, with the date and then the signature. Moving on to pre-trial settlement conferences. Part of what happens between the time of filing initial pleadings and the start of the trial is that a judge will conduct one or more pre-trial conferences. See, for example, Federal Rules of Civil Procedure number 16. During a pre-trial conference, which doesn't usually take place until after you've had a chance to gather documents and evidence, a judge will meet with you and your adversary's lawyer for any of a variety of purposes. For example, a judge may use a pre-trial conference to schedule hearings on motions or try to shorten the trial by getting you and your adversary to stipulate, that is, to agree to particular facts. However, probably the main reason that judges schedule pre-trial conferences is to facilitate settlements. Rules such as Federal Rules of Civil Procedure 16A authorize judges to order the attendance, either in person or by telephone, of parties who have the power and authority to settle the case. The style that judges use to conduct pre-trial settlement conferences varies widely. Some judges act much like mediators, trying to facilitate discussion and help the parties arrive at their own settlements. Others take a more active role, sizing up, quote, what a case is worth, unquote, and trying to cajole or occasionally even browbeat the parties into a settlement, sometimes by caucusing with each side individually, as mediators often do. Some judges require parties to prepare a confidential, that is not shown to the adversary, settlement memoranda, justifying their settlement demands or offers. Finally, judges sometimes even ask lawyers to cut their fees to facilitate a settlement. If you are a self-represented party, obviously you'd like to know in advance what to expect from your judge during a settlement conference. Unfortunately, because these conferences usually take place in judges' private offices, often called chambers, you won't have a chance to watch your judge in action in another case. However, you can consult with your legal coach, who may have some experience with the judge or know someone who does. You could also ask a judge's clerk or secretary about a judge's preferred method of conducting a settlement conference. When thinking about what sort of settlement you would accept, it is important to be realistic about what is likely to happen if your case goes to trial. If you are a plaintiff, ask yourself questions such as, what are my chances of winning? How much money am I likely to receive? How much time and energy will it take to prepare for trial? And how will that affect my business or other activities? How long will the trial take? And to what extent will it disrupt my life? Will I have a hard time collecting the judgment if I win? If you are a defendant, ask yourself questions such as, what are my chances of winning? How much time and energy will it take to prepare for trial? And how will that affect my business or other activities? How long will the trial take? And to what extent will it disrupt my life? What's the possibility that a judge or jury will order me to pay much more than I could settle for now? Can the publicity of a lawsuit hurt my reputation or business? Here's a tip. If you have limited experience with the court system, get help before going into a settlement conference. As a self-representing party, you may not have enough experience with the legal system to feel that you can answer the above questions with any degree of accuracy. You might ask a legal coach to help you craft a reasonable settlement offer or evaluate the other side's offer. At a pretrial conference, it is easy to feel like an outsider, especially if your adversary is represented by a lawyer. You might even feel as if the judge and your adversary's attorney
are ganging up to force you to accept a bad settlement. On the other hand, a judge's experience can help guide you to a settlement outcome that is at least as good as you are likely to achieve at trial. While it's important not to be buffaloed into saying yes to a bad settlement, you'll also want to avoid being so angry at your adversary or so emotionally invested in your case that you pass up a chance for a reasonable compromise. Again, a discussion with your legal coach before a settlement conference can guide you toward a realistic settlement outcome. Pressure to settle. The consequences of saying no to a judge. If you are self-represented, you may be concerned that refusing a settlement a judge is urging you to accept will turn the judge against you at trial. Start by understanding that in many localities, the judge who presides over a settlement conference is not the same judge who will preside at trial. In any event, most judges' court rulings will not be affected by your refusal to settle. However, if a judge's behavior or statements during a settlement conference indicate that the judge may have already arrived at an unfair conclusion about your case, the laws of most states allow you to file a motion to disqualify, asking that another judge be assigned to preside over your trial. Attorneys' practice guides available in a law library will probably have a sample motion to disqualify. And then moving on to the final section of this video, post-settlement documents. Settlements are typically accompanied by a number of documents. This is the legal system after all. The terms of the settlement may be set forth in a written settlement contract called a release or a stipulation for dismissal. If your adversary's lawyer prepares the contract, it is critical that you read it over carefully, perhaps ask for modifications before signing. A settlement contract is enforceable in court, just like any other kind of contract. And if you later claim that the adversary is not living up to the settlement, then only the written contract, not the oral discussions leading up to it, will establish your rights and obligations. The language of a release, sometimes also called a general release or a release of all claims, is often quite broad, typically terminating all of plaintiff's claims, existing and unknown, against all existing and potential defendants. Your state may have a law providing that releases do not extend to claims that you don't know about. If so, you'll probably have to waive or give up that protection in the release agreement. For example, if you receive $10,000 to settle your personal injury claim, you will probably be asked to sign a release not only on your behalf, but also on behalf of your heirs, agents, and assigns. In addition, the release will probably state that the settlement covers every possible type of injury, including personal injuries, property damage, physical disabilities, medical expenses, lost income, loss of consortium, and other claims that have been or could have been brought, whether now known or that might become known in the future. It may seem unfair for you to be asked to settle possible claims that you aren't even aware of, but courts routinely uphold this type of broad release language and rely on it to justify barring future lawsuits growing out of the events referred to in the release. Before signing a release, you should be certain of the full extent of your property losses and personal injuries. Example number one, you slip and fall outside a department store, which you then sue for improperly maintaining the sidewalk in front of the store. You agree to drop the suit in exchange for a payment of $5,000 to compensate you for medical expenses of $1,500, lost wages, and pain and suffering. You sign a broadly worded general release of all claims under which you agree to dismiss the lawsuit and irrevocably release the department store from any future claim growing out of your fall. A month later, your doctor tells you that your injuries are not responding as well to treatment as the doctor expected, so you'll need around 6 months of additional therapy, costing an additional $2,000. You cannot refile the case or seek additional money from the department store. The release terminated all your claims, both known and unknown. In example 2, in the same case, the department store offers to settle your case by paying you $5,000 if you dismiss the case and signed a general release of all claims. Trying to decide whether to accept the offer, you check with your doctor, who tells you, at this point I can't be certain how much more treatment you need. Normally you'd be looking at a few months of therapy costing around $1,500, but you've been a little slow to respond to treatment, so you could be looking at expenses of twice that or even more. In this situation, you should probably ask for additional time to accept or reject the settlement offer until you have a firmer sense of the extent of your medical bills. If you accept the offer and sign the release, you'll have no recourse if your medical expenses turn out to be greater than you thought. A stipulation for dismissal, when filed with the court, means the case will be terminated, usually with prejudice. The term "with prejudice" indicates that the case cannot later be reopened or refiled as a separate action. Secret settlements. It is common for a release to require that you keep confidential the amount of money you receive in a settlement. For example, a release may state, "This settlement is confidential and neither party shall disclose the terms of the settlement to anyone, whether orally or in writing. Failure to maintain confidentiality voids the settlement." Such language is especially popular with businesses that fear that public disclosure of settlement terms will encourage litigation. If you want to settle, you'll probably have to agree to confidentiality. So that's where we're going to conclude our video for today. Next video, number 7, we're going to get into pretrial motions. We're going to do an overview of the pretrial motion practice. When you make a motion, who can make a motion, the basic motion process, and frivolous motions. We'll discuss whether a motion is necessary, what goes into a motion, scheduling a court hearing on a pretrial motion, serving and filing your documents, court hearings on motions, and we'll also discuss common pretrial motions such as motion to dismiss, motion for continuance, discovery motions, and motion for summary judgment. So, until then, we hope that you've enjoyed this educational video, and we thank you for taking the time to improve the quality of your life and the breadth of your knowledge by studying law with us. Thanks so much again. If you've enjoyed this video and the others in this series, please go ahead and share and recommend them to your friends, because it has by becoming an informed populace, we can reclaim our true power as a people by a firm understanding of the law and how law operates. So thanks once again, and we will see you next time. And until then, be blessed.